Good morning, almost afternoon to everyone who's on the line. I think we'll get it started. It's 11 o'clock. We have until 12 and we have a lot of stuff to discuss. So I'll start by thanking everyone who's on the line for attending our labor and employment webinar on secret employee recordings. My name is Dominique Fontaine. I am a partner practicing in our Moncton office. Also on the line is my colleague Brad Proctor, who is a partner practicing in our Halifax office.
Good morning.
It's a pleasure to have you all attend this morning. We had a good number of attendees registering for this webinar. And as always, everyone is going to be muted, but you will have the ability to ask questions as we go in the chat box, and we'll get to questions either at the end or as we go. We've put some time aside to answer your questions at the end of our presentations. And we also did receive some questions that were pre-submitted when you registered for the seminar. So we will address some of these questions too throughout the presentation. So we'll go to the next slide. For our first webinar of the year, we opted to talk about the subject of employee recordings. And we did that for different reasons, but in our respective client seminars that we did in the fall of last year, we did have a couple of questions from clients on this subject. And during some of our group discussions in the labor and employment group, we realized that we were getting more and more questions from clients on this subject. So it's definitely a hot topic. And it's not necessarily that, all employers have been faced with this issue of having employees secretly record meetings, although some of our clients have, unfortunately. But it's also that, managers, HR professionals, supervisors are starting to realize and understand that it's somewhat of a trend that employees do that. And I think there's different reasons why we're seeing this type of behavior more and more from employees. First, well, it's the ease of doing it through our smartphones that we have with us all the time. We can have in our pockets. It's very accessible. There's also the prevalence of remote work. So employees have, they're at home, they have the ability to record even through employer equipment. Sometimes I attend meetings on Teams or on virtual platforms where at the end of the meeting, there's AI that summarizes what we've discussed. So some of those platforms record meetings. And there's also a trend on social media where employees can upload live videos. And there's also, it's on TikTok and on Instagram, there's different platforms. And there's some examples, I know last year, of videos going viral of employees that are getting terminated. So there's an example that I'm thinking of specifically, which I find particularly cringeworthy, but it's an employee who is getting terminated. She's at home sitting at her chair and she's recording herself having that discussion with the two HR professionals, which are doing a great job. But it's a 9-minute video that was posted on TikTok where she's quite combative and it went viral. So I think that it's timely to ask these types of questions, and it's important to do so. Is this legal to do for employees? Does secretly recording conversations with employers amount to cause for termination of an employee's employment? There's also questions around the admissibility of these recordings. Can an employee use secret recordings as evidence in court proceedings, in labor proceedings, arbitrations, human rights complaints, etc.? So all of these questions we'll try to answer during our webinar. And just so everyone on the line knows, this webinar is more focused on employees recording meetings than it is focused on the ability of employers recording meetings. I know we have a couple of questions on kind of that other perspectives, so we can answer those questions. But the focus really today is on employees that are recording meeting. We also will aim to provide you with practical advice on helping you minimize the risks involved with meetings that are being recorded. So the first question that we will often get, because I mean, I think we can all agree that it's quite unethical to record a conversation without the consent or the knowledge of another person, but is it illegal? So in Canada, we have what we call a one-party consent rule. So as long as one party to a conversation is aware that the conversation is being recorded, it's legal to record the conversation. So if I was to record a conversation with Brad without Brad's knowledge, that's legal. But if I was to record a conversation that Brad was having with Joseph in the office and I'm not there, that's not legal because there's not a party to the conversation that consents to the recording. So it is legal in the sense that it's allowed under the Criminal Code of Canada. Of course, it's not because something is not prohibited under the Criminal Code of Canada that it is, one, admissible into evidence, and two, appropriate to do in the workplace. So when we think about recording of meetings, there's different questions with different burdens of proof. It is legal, but is it admissible? And can it be cause for termination? And that's really the focus of the presentation. So if we go in the next slide, a question that was submitted to us in advance of the recording, which is a great question, is, does secretly recording conversation with an employer amount to cause for termination of an employee's employment? The ultimate question. And as always, you're going to hear us say, well, maybe. It depends on the specific circumstances. And we brought forward 3 cases that I'm going to discuss where that is specifically the argument that was put forward by the employer to say, I have cause for dismissal because the employee has secretly recorded conversations and the trust relationship that is required has been broken. And you'll see the ruling of the decision maker will depend on the circumstances. The first decision is a decision from the British Columbia Employment Standards Tribunal, and it's an older decision than the other ones that we're going to discuss. It's from 2019. And the question, because it was a complaint filed under the Employment Standards Act or the equivalent in British Columbia, the question before the tribunal was whether the secret recording of a conversation by an employee amounted to serious misconduct under the code. So in this case, the complainant, who was the former employee, filed a complaint with the Employment Standards Branch for wages, overtime, vacation pay, all the wages that you can imagine. Prior to the complaint being filed, and prior to the employee resigning, he said constructively dismissed from his employment, what happened was the employee had a meeting with the employer, and during which they discussed his entitlement to wages, overtime wage, holiday, etc. The employee secretly recorded the meeting. Surprise, surprise, this is what we're talking about. And in the recording of the meeting, the supervisor can be heard saying he had not reviewed his claim for wages yet, but he would be looking to make adjustments downward. And the supervisor can also be heard saying that they needed to get the question of wages resolved one way or the other before the employment relationship could carry on. So the complainant left that meeting interpreting the statement to say that his wage claim needed to be resolved before he was allowed to return to work. So he followed up with a letter saying that he had been constructively dismissed and seeking, all types of wages under the act, including severance. The employer, on the other hand, took the position that the employee quit. So the question was, did the employer have after acquired cause based on the secret recording? So the tribunal found the following, and this we would know that to prove just cause, the onus is on the employer to show that the behavior is inconsistent with the continuation of employment. The tribunal found that in some cases, secretly recording the employer can have substantial detrimental effect on employer-employee relationship. But in this specific case, it wasn't deemed to be serious misconduct because of the circumstances that led to the recording of the conversation. And those circumstances were not inconsistent with the trust relationship required. And these special circumstances were that the purpose of the recording was related solely to the employee's attempts to corroborate his claim for wages. And the second reasoning that the tribunal adopted was that the recording was not intended to embarrass or otherwise bring the employment into disrepute. So I just want to make a note here. This is a decision from the Employment Standards Tribunal in BC. It's not binding in our provinces. I think it's relevant to say the circumstances are important, the context is important. I don't necessarily agree that the question of whether or not the intent was to embarrass the employer, I don't necessarily agree that that's a relevant factor for the after acquired cause piece, but it was a consideration in that case, and it really emphasizes that the entire context is relevant. Brad, do you have thoughts on that, on whether or not the intent is to embarrass being a relevant factor?
I think I would concur with what you've said, Dominic. I don't have any view different from yours. I think everything is contextual, right? And as we'll talk about as we go on in the presentation, the purpose of the recording, is it being used to advance a right that the employee has, or is it being done to embarrass the employer? Those will be relevant considerations.
Right. Yep. Okay, so we can move to the next slide. And this is, that's the outcome that I just discussed from the BC tribunal. So the slide on the Rooney case, it's Rooney versus GSL Chevrolet Cadillac Ltd. That's a more recent decision from the Alberta Court of King's bench. And in this case, the plaintiff claimed that he was constructively dismissed by the defendant. And his claim of a constructive dismissal was substantially based on changes that were made to his role and his income, and on the fact that he had been put on a leave without pay by his employer. Of note, the constructive dismissal, resignation, occurred 10 years before this trial was heard. So it just goes to show how litigation can be lengthy, but it went all the way to trial. And the first day of the trial, employer counsel moved to amend its statement of defense to allege after acquired cause because the employee had secretly recorded conversation with his employer. The court basically said it's too late. There's no reason why you're trying to amend your defense on the date of trial. It's been 10 years. It should have been done way before then. But the court still went into the analysis of, if I would have allowed the statement of defense to be amended, what would have been my ruling? So for our learning purposes, it's an important case. And the court also made a ruling on whether or not the recording was admissible into evidence in the civil proceeding. So there's two aspects to this case: the admissibility of it and whether or not there was cause to terminate. And that's an alternative thing because that's not a real defense, as I said. On the issue of the admissibility of the recordings into evidence, so the plaintiff was testifying on the recordings. There was an objection by the employer counsel saying, no, this can't be put into evidence because there was no consent. And basically, there was two big arguments made by the employer. One, the recording was of poor quality. The court did not accept that one. But the second, I think, most interesting objection was based on the fact that employer counsel said this is a matter of public policy. Workplace recordings should not be admissible because to do so would encourage secretive recordings and undermine the employer-employee relationship. So the analysis of the court on this specific subject is quite interesting because the employer relied on two labor arbitration decisions, which essentially ruled that the evidence could not be, that the recordings could not be entered into evidence because of public policy concerns that it would, undermine workplace cooperation, collaboration, open settlement discussions, etc. So there was two decisions from BC from labor arbitrations that ruled no, we're not going to admit these recordings into evidence. But the court at King's Bench said, okay, well, at common law, the common law rule to determine whether or not something is admissible into evidence is that we must weigh the prejudicial effect of the evidence versus its probative value. That's the test. And the court said that at common law, when we do that exercise, we do not consider public policy matters that are external to trials, such as public policy interest in maintaining positive workplace relations. So the court said maybe in the arbitration context, that's a relevant factor, but here in court at common law, it is not. So the court said, I accept this recording into evidence. I do not accept the objections raised by the employer. So that was the reasoning on the admissibility of the recording. In terms of the argument for after acquired cause, the court found the following. Yes, recording conversations in the workplace will often cause irreparable damage to the relationship of trust. That's the general rules. And some previous decisions have found this. However, in this specific case, there were some factors that applied that made the general rule not applicable. First, the court pointed out that the employer had two written policies, and Brad's going to talk about the importance of policies in his section, but the employer had two policies, the corporate ethics policy and a phone usage policy that didn't address this specific question of consent and of recording. And the court also pointed out that the policies state they required employees to sign off, and there was no evidence that this employee had signed off on the policy. More significantly in this case, putting aside the policy issues, what the court explained is that in this case, the employer-employee relationship, when the recording was made, the relationship was already frayed by tensions, and the employee had an emerging appreciation that he was being constructively dismissed. There had been, at that point, when he recorded it, a fundamental change to his terms of employment. So the comment made by the court was, okay, he resorted to an unethical tactic, but it was to deal with this relationship power imbalance in which he was in, where the employer was imposing new terms and conditions on his employment. The court found that his actions were justified in recording the conversations because the employer exerted its power over by the employee by imposing those unilateral changes to his employment terms and disciplined him contrary to the terms of his employment. So that analysis on the power imbalance and the justification for recording, that was not to the admissibility of the evidence. It was the distinct question of whether or not it could have been after acquired cause. So basically, the court said, even if I would have allowed you to amend your defense to say you had after acquired cause, I would not have accepted that the circumstances of the case warranted a for cause termination. The next slide is another case from 2022 by the British Columbia Supreme Court. And it's interesting because it reached an opposite decision, just to show how context is important, right? And that's the case of Shalagan versus Mercer Limited Partnership. So the sole question in that case was whether or not the secret recording of of fellow employees, it wasn't just one recording in this case, it was several recordings of several employees in the workplace, whether that, I guess, practice was the basis of a dismissal for cause based on after acquired cause. So in this case, I was reading through it. There's a lot of details of the evolving employment relationship in this decision, but ultimately what happened was there was some disagreements between the employee and the employer about a bonus entitlement. The conversations got heated, and after these conversations occurred, the employee sent an email to his manager saying, I'm open to resolve the disagreement about my bonus in a timely manner and internally without proceeding to litigation. So the employer said, whoa, you're threatening us with litigation. You're out. We're terminating you. We're not going to allege cause. It's just, we can't continue with this employment relationship. So they terminated him without cause. The employee turned around, filed a claim, filed a human rights complaint also. In the context of the human rights complaints, it was disclosed that he had recorded a significant number of meetings with colleagues, supervisors, HR personnel over a period of 10 years. He had all sorts of excuses for the recordings, saying, initially I was recording it to help me learn English, but the court didn't agree that that was a reason for recording. The employee admitted at trial that he had not asked for the permission because, in his view, it was not illegal for him to do it, and he was aware that it could make people feel uncomfortable if they knew there were some recordings. In this specific case, the employer had a code of conduct and some confidentiality policies in place. So when the employer received the human rights complaint, it said, whoa, well, we have after acquired cause. We just learned that you have been secretly recording employee meetings for 10 years. We didn't know that at the time of termination, right? That's the concept of after acquired cause. You have to learn of the cause after the termination. And the court essentially agreed with the employer. The court said, yes, you have after acquired cause. The court recognized that maybe initially the recordings were to help him learn English, but throughout the years, his sensitivities toward his colleagues' privacy began to loosen up. He knew it would make other people uncomfortable. He knew it was unethical. And a lot of those recordings included conversations with personal details that were not related to the workplace about coworkers. And on the piece of privacy, the court wrote something that I thought was interesting. So I'll just finish by quoting that on the privacy concerns, and then I'll let Brad talk. But the court said, looking at the effect on employment relationships more broadly, Accepting the plaintiff's argument may encourage other employees who feel mistreated at work to routinely start secretly recording coworkers. This would not be a positive development from a policy perspective, particularly given the growing recognition that the courts have given to the importance of privacy concerns. So, and then they quote a decision from the Supreme Court of Canada. So you may think, okay, well, you just told me that in the other decision, those public policy concerns were not relevant. But the distinction is in that prior case, the policy concerns were not relevant to determine whether the recordings were admissible. But in this case, the policy concerns were relevant to determine whether there was cause to terminate. When we think about kind of the different burden of proofs and the different questions, they were that context was for different reasons. So with that, I will let Brett talk.
Thanks, Dominique. It's amazing as I listen to Dominique talk, and we talk about this topic, which has become very timely and very relevant, how the introduction of technology changes things. Because if we go back 25 years and think about an employee who would have brought a tape recorder into an office and secretly recorded someone and then transcribed that and put that in the newspaper, we would say, oh my lord, that's horrible. But now we're talking about someone with their phone in their pocket who's able to record a meeting and hit post and have it on Instagram or have it on social media. So what I'm going to talk about is a step removed from what Dominique just talked about. I'm going to talk about the employee that makes that recording and then tries to post that recording on social media. And there's a number of factors here to keep into consideration. What we're talking about here is an employee doing this while still employed. It happens, and I've seen this happen in our provinces and with our employers, probably some people on this call, where someone gets terminated, the employment relationship is over, and then they post stuff, they post recordings. I've seen that. But what we're talking about here is the person posting while still employed. So we've developed some case law on employees doing things in the off duty and employees doing things on social media. And there's a test that's been developed that gets applied, but so much of that test is contextual. And when you think about the contextual factors that you need to think about in something like this, the factors include what type of workplace is it? Is it a unionized workplace or is it a non-union workplace? As Dominique mentioned, the courts, for the common law courts, will treat something and look at things more narrowly than labor arbitrators will. Labor arbitrators will look at public policy. So that makes a difference. Is the workplace, is it a private sector workplace or is it a public sector workplace? In Nova Scotia, we don't really have private sector privacy legislation. In Nova Scotia, all of our crown corporations, universities, government agencies are governed by FOIPOP. So there's an additional legal regime with respect to privacy that applies in certain workplaces. Some provinces have private sector privacy legislation, so that's a factor. Are there policies? Almost on all the cases that Dominique mentioned, the courts were looking, is there a policy on this? What does the employer's code of conduct policy say? What does the reasonable use policy say? So what is the policy? What is the employee saying? Are they advocating something that might be protected by free speech? Or are they trying to be malicious and possibly defame the employer? That's contextual. In other words, is the employee trying to protect a right that they have? Are they trying to protect a human right? Are they trying to protect a health and safety issue? And are they breaching other people's privacy? Are they breaching management's privacy? Are they breaching coworkers' privacy? Are they breaching customers' privacy? So all of those things get put into the blender, and you look at each thing on each case on a contextual basis. And so, for example, you can look at different ends of the spectrum. Say we have an employee who's ticked off at their employer. They post an interaction with a customer, and they put it on social media that my employer is a thief and doesn't treat customers fairly. Well, that's one end of the spectrum. We've got defamation, we've got violation of a customer's privacy, we've got all kinds of bad things. But what if we have an employee who feels that they've been racially discriminated in the workplace and they're not satisfied with the employer's response, and they say, I'm going to go to the Human Rights Commission because my employer is not, looking into my particular characteristics. That's a different end of the spectrum. So much of it is contextual. If we go to the next slide, for those cases involving employees who take a secret recording and post them online or post them to social media, courts and arbitrators have applied this test. This test comes from an age-old case called the Millhaven Fibers case. It's not new, but it's kind of the best legal test that's been applied in these cases. And there's a whole series of factors that we look at to say, is the posting of that disciplinary? Because it might be okay for me to make that recording. And if I was making that recording for my own personal use to protect myself, or I was making that recording for a particular legal claim, whether it be an ESA claim, that's one thing. That might be okay. But taking it and putting it on social media, that's no longer for my own personal use. That's not for a legal case. So that may be a step too far, and quite often will be a step too far. And so when we look at these factors, like I said, this case comes from 1965. This is before cameras and recordings on phones existed and before social media existed. So some of the factors don't apply. But if we look at the first factor is probably the key factor in my view, which does it harm the employer's reputation or product. So if I have an issue about safety, then I should deal with my employer directly on that. I should deal with the Department of Labor on that. But putting it out on social media, that's not an end to me. That's not helping me with my case. That's simply harming the reputation of the employer. Does it render employees unable to perform their duties satisfactorily? Not as important a factor. Does it lead to refusal, reluctance, or inability of other employees to work with them? That's a big factor. You're in a workplace and you're recording meetings, you're recording a staff meeting, you're recording interactions, and remember, supervisors are employees as well. And so I post a discipline meeting about my supervisor. Does it render them reluctant to want to work with me? Sure it does, right? So those factors are important. I don't see the fourth factor as important in this context, the employee guilty of a serious breach of the criminal code, because we know that single party consent is criminally, it's legal. So that's not as big a factor. And does it place difficulty in the way the employer's ability to properly carry out their function, efficiently managing its work? So there's trust issues, right? If I work in a position where confidence and trust is important, and here I am blasting out something on social media, that could hurt that trust relationship with my employer. Next slide. So one of the things we talk about is, employees making these recordings, single party consent, one party consent, as Dominique mentioned. But the question is, can we get these recordings into the court of law, the proverbial court of law? And the court of law might be a different type of tribunal. So it could well be that we're dealing with let's say it's a human rights tribunal. Let's say it's an occupational health and safety matter. It could be a labor arbitration. So I've made the recording, but just because I've made the recording and just because it was legal for me to make the recording doesn't mean I have the right to admit that recording into evidence. If we go to the next slide. This is a case, Telger versus Aurora Hotel Group. As you can see, it's a very fresh and recent case. It's an Ontario Court of Appeal case from 2024. And basically what happened in this case was an employee was being terminated. And as most employees are fairly savvy, all of a sudden you're told, hey, there's a meeting we want to have with you on Friday, tomorrow morning at 10 a.m. And it's outside the norm. And, you're going to be there and you look at the meeting request and you see it's your boss and HR. Okay, something's coming. It doesn't seem good. That's out of the ordinary. So the employee goes to the termination meeting, and the employee secretly records the termination meeting. And afterwards, the employee sued. And by the way, the employee did not say I'm recording, didn't ask for permission, didn't ask for consent. They just did it. And the employee then sued for wrongful dismissal. And of course, when you sue in civil court, any document you want to put in, you got to disclose up front. So, I have this secret recording that I made. And the employer took the position, well, we didn't consent to that, and it's prejudicial, and we don't want it to come in. And so there was a dispute over that. And part of the employee's claim for damages was an allegation of bad faith in the manner of termination. The employee was saying the way you did the termination meeting was bad faith. And what the employer had done during that termination meeting was they had said, Mr. Telger, you've done some wrongdoing. We suggest that you resign. You should proffer your resignation. And of course, the employee didn't resign. So they said they made some allegations that he may not get a severance, and ultimately the employee was terminated. And so the court found that the allegation of bad faith in the manner of termination, that recording was relevant, and that the recording was relevant, and the recording was readily admitted and went to the way which that employer conducted that termination meeting. So the recording went in, the recording was relied on, the recording was played in open court, and based on that recording, the court found that the employer did engage in bad faith in the manner of termination and awarded additional punitive damages to the employee for bad faith in the manner of termination. We can go to the next slide for a moment. So the lesson here is that, as employers, and a lot of these lessons aren't new lessons, but you can have that type of meeting, and you can have that type of meeting where you give an employee an alternative to resign. But how you do it is the way. And having the letter drafted in advance and providing the letter with the without prejudice alternative, that's all the way you do it. But calling that employee into the meeting and kind of doing it the way they did was found to be bad faith. And that case was upheld at the Ontario Court of Appeal. So when we talk about, and I'll just leave on this admitting these things, when we talk about admitting evidence, Dominique's already mentioned, it's going to be a very low threshold for an employee to legally record. Hey, single party consent. You don't know I'm even doing this, but I know, and I'm consenting and I'm recording it. That's a very low threshold. Then to get that into a court proceeding is going to be a higher threshold. And courts have mechanisms to determine whether or not something comes in. If I think about things in the criminal context, so things that play out in our provincial court system, there's a system of what we call voir dires. So for example, if there's a piece of evidence that might be, does it come into the court or not, the judge does a little trial within a trial called a voir dire, where the judge will say, okay, is this recording going in or not, right? If we think about civil court, which was this wrongful dismissal, there's what we have pre-trial disclosure, pre-trial discovery, and if someone doesn't want something to come in, they can make a motion prior to the trial to dispute whether or not that piece of evidence comes in or not. And then in arbitration, in unionized contexts, we can do a motion as well. Or sometimes arbitrators will say, look, I'm here for 2 days hearing this case. I'm going to hear the evidence. I'm going to receive the recording. I'll receive the closing arguments about whether the recording goes in or not. And when you get my final written decision, I'll decide whether or not it's in or not. So there's different mechanisms for these things to get in. But just because it's legal to make a recording doesn't mean it's going to get into the legal process. And then once it gets into the legal process, if it doesn't mean there's going to be significant weight placed on it. So there's all these different thresholds that get applied to these. So with all that being said, and in the interest of giving people time to ask questions at the end, we're going to talk about how do we mitigate some of these risks of recordings in our workplace. So if we go to the next slide, what we're seeing quite frequent in our practices in Atlantic Canada and beyond is we are seeing secret recordings. Like, let's be frank, we are seeing secret recordings. We're seeing employees go into accommodation meetings, employees going into performance management meetings, employees going into discipline meetings, just any type of interactions with supervisors where either the employee is simply doing a voice recording in their shirt pocket, or a lot of our meetings with employees, with kind of people working from home, have gone to this platform. And so it's fairly easy for me to have my phone beside me recording this meeting and you not to know, or to have a camera over my shoulder recording the screen and you not to know. And we are seeing that happen. We're seeing that going on. But when we think about it, what is that type of meeting? Are we having a business meeting where we're talking about our confidential business? We're talking about our trade secrets. Is that being recorded? Because if an employee were simply to take handwritten notes of that type of meeting and disclose that, that would be disciplinary. So we're seeing that happen. We're also seeing, as Dominique mentioned, the more and more virtual meetings we're having, it's relatively easy to record. Now, if we were recording, and we probably are here, we are. If you look in the corner, you'll see a little red record button, so you know we're recording this. And I think when we use Teams and Zoom, for the most part, if someone's recording that, we know it's being recorded. But like I said, people can put things out of the view of camera and record. And also there's a function in Teams, and I'm sure Zoom as well, where some organizations, just as a matter of course, have their meetings transcribed, right? And so we could be talking here, and at the end, through the click of a button, the transcription of this whole meeting that we've had gets put out, and whoever's spoken, it says who spoke, and there's some typos in it, but that is happening as well. So those are the types of things that we're seeing in our more virtual workplace. And I will go out on a limb here to say most of your policies and procedures don't restrict or contemplate or speak to that. I bet you very few have a policy or procedure on that. And I'm not suggesting that you run out and necessarily do a standalone recording in the workplace policy, but as Dominique mentioned early on, she said there's code of conduct policies, there's responsible use policies that how we responsibly use the internet, how we responsibly use our phones. Those are the right types of policies where you can put restrictions in about recordings in the workplace. So we move to the next slide. So some of the risk mitigation strategies that we recommend are put it in a policy, either a standalone policy, adopt your responsible use policy, put it someplace, and restrict what you want to restrict. You can, like I said, use an existing policy, and you can say in our workplace, you're not to conduct secret recordings, or you're not to record without consent, and you're not to post online. Those are different things, right? The threshold for recording might be a little lower than posting online, but absolutely you don't post online. They're different things, and you want to restrict both of them. I think that courts, arbitrators look much more unfavorably on people posting stuff to social media than someone making a recording to protect themselves and use in an arbitration or use in a human rights case. So decide what you want to do in your workplace and put it in a policy. The next thing to think about, and I've talked about this already, is to contemplate the location and to say the more and more that we have virtual meetings, people are not to record unless everyone consents, or people are not to do transcripts unless everyone consents. Or we're disabling the recording function, or we're going to record all meetings. Whatever it is, turn your mind to the location of how you want what you want to protect. I'm going to be frank with you. What I tell people and what I tell clients and HR managers and owners of company is assume the worst. In today's environment, assume the worst. Assume that if you are going into that accommodation meeting, that discipline meeting, that termination meeting, assume that you're being recorded. And by doing that, you're going to be professional. You're going to be, judicious in your words that you use. You're not going to go off script. You're going to be disciplined. That's what we tell people. And I know we're not here to talk about union organizing, but of course in union organizing, that's another context where, there's lots of recordings happening, right? Boss, tell me what you really think about unions, right? So just assume that you're being recorded and be disciplined, which kind of dovetails into the next point, which is stick to a script. As lawyers, we say, take notes, take notes, take notes. You're having a termination meeting, you're having an investigation meeting. Have your script, have your points, because that's going to help you stay on script. If you have a termination meeting, think about it. You have a well-drafted termination letter. If it's for cause, it gives the reason for the cause. It talks about when it's effective. It talks about what's going to happen to your pay and benefits. During the meeting, really going through that letter, there's not much more you have to convey. So stick to that script. Don't get into debating the merits of cause during a termination meeting. Don't get into negotiating during a termination meeting. So stick to your script. And it's even more important that you have that witness, right? We always say have two people go into difficult meetings. Why? So that's why you have a witness. You have someone to say, well, that's not the context of which that was raised, or that's not how that came up. And so even more important to have a witness. And so as we kind of wrap up this and move on to your questions, I've just kind of to summarize very, very briefly, if I can kind of summarize the 3 points that, collectively we've made, point number one is that, secret recordings, and I think this surprised a lot of people, they're generally going to be legal, right? Single party consent. They don't need your consent, so they're generally going to be legal. So that's point number one. Point number two, just because the recording is legal doesn't mean it's going to get admitted into court, admitted into the Human Rights Tribunal, admitted into the Labor Board, right? Doesn't mean that. There's a higher threshold for admissibility, and of course, what weight is placed on it. And then the third point is, just because it's legal doesn't mean that it might not be cause for discipline. There's lots of things that are legal, right? Like I might be a professional environment where they expect me to wear a jacket and tie. It's legal to wear cut-off jean shorts and flip-flops, but my employer says we have a policy, we have a dress code. You can't wear that to the business meeting, right? It's legal to consume alcohol. It's legal to consume drugs, but my employer might say our policy says you can't do that during work. So something can be legal, but we can have a policy that sets a standard for the workplace. So that's kind of the takeaway: is the cause for discipline on this. The lay of the land on the law. Adopting your policies and procedures to restrict some of these things is what we recommend, so that if you get into a situation of someone posting something, you can point to a policy or a rule that they've breached. So that was kind of our planned presentation. We've left some time for questions. I think there's some questions that have been emailed, and so we'll answer your questions.
Yeah, maybe I'll ask you, Brad, a question that was pre-submitted here. Because you talked about some people posting recordings on social media platform and off-duty conduct. And the question was, if the recording is a post on a social media platform, do we have a legal right to have them, the employee or former employee, remove that post from social media?
Yeah, I mean, yes. I mean, the answer is yes. You have the legal right, and once again, it depends what they've put up there. So, we go back to, and I'm using kind of extremes. If someone says that they've been discriminated in the workplace and they're going to the Human Rights Commission and they have in fact filed a human rights complaint and they post that, well, that's a true fact. Probably hard to get that down. But if someone is saying my employer doesn't, care about safety of employees, or my employee or my employer, then those are defamatory statements. And so you absolutely have the right to write to the employee and say, please take that down, or not, please take that down. We require you to take that down. And if you don't, then we will be suing you for defamation. That's if they've departed. And sometimes you can even go to the social media platform itself and say, there's been, illegal conduct happening on your platform, and you have a terms of use policy that people aren't to engage in harassment, discrimination, defamation, and we're requiring you, Meta, to remove that. So there's different things you can do, and yes, you have the legal right to demand it.
There's a pre-submitted question too, and we just got a question that is on the same vein. It's, if an employer requests to their employer that the employee wants to record the conversation, can the employer say no? And we also had a similar question: can you ask employees to leave their phones outside of the room where the meeting is taking place? I think that ultimately the decision of whether or not you allow that to happen or is the employer's decision. So if you have an employee who's refusing to participate in a meeting if they're not allowed to record, as a general rule, I would say you proceed with the meeting and you say you are not allowed to record. If there's no agreement by the employee, I think that eventually you could look down at the disciplinary line, or to say that's our rule. If you don't want to comply with our rule, then it's insubordination. Obviously, that will depend on kind of the context and what is the subject matter of the conversation. But I would say that you can hold tight to that general rule, or you could say, you know what, you want to record, we have nothing, we have nothing to hide, you can record, we're going to record also. That, I think it depends on the circumstances.
Yeah, I agree, Dominique. And I think this is one thing that, like, here we do this presentation today for an hour and give you some tidbits. I think it's something that you should take away and think about, because you're going to go down a path, and once you go down that path, we're going to say you should be consistent, right? So if you're going to say, you can record, right? If you go that path, then it's going to be hard to pull that back on future cases. Next thing you know, everyone's recording, right? And so whatever path you go, as Dominique mentioned, I think you got to be consistent. And it's not uncommon. Like, the recording thing is kind of not new. And so what I've told clients in the past is, when an employee comes in and says, I want to record, you can say, look, I'm your HR person, or I'm your boss, and I'm not comfortable being recorded, so I'm not consenting. I'm not letting that happen. So what I will do, though, is we can end this meeting, we can reschedule it, and you can come back with a notepad, and I'll go really slow, and you can take like all the notes you want to take. And I won't start asking the next question until you've taken notes. Or if you want to get another person to come in with you and help take the notes so you can be engaged in the discussion, we'll reschedule and let that happen. So you can provide those alternatives. And if they don't go for those alternatives, then you can say, then you can, I think you look even more reasonable going in subordination because you've given them some alternatives.
There are some questions too around. At times, I have had employees request to record our meetings. I have stated as the employer, the HR professional, no, I don't consent. And how could this impact the employer's ability to use the recording as evidence? So I think that ultimately, if you don't consent and the employee still does it, we've already established it's legal because it's allowed under the criminal code. Whether or not it can be admitted into evidence, I think in a labor arbitration, when we think about those policy concerns, that could be a relevant factor to the admissibility. I think it would be a little harder to make that point in court regarding the admissibility because those public policy concerns would not necessarily be considered by the court. But I think at the end of the day, if you are to allege cause and the employee knew you did not consent, that would be a relevant factor to support the for cause termination. What do you think, Brad?
I agree.
Yeah.
I totally agree. Yeah.
Oh, here's another one, Brad, that you may want to answer. What options would an employer have if the union records the meeting between them, the employee, and the employer?
So yeah, I don't think it really changes things because remember, single party consent doesn't mean it's just a two-party conversation. It can be a multi-party conversation. So as long as I'm engaged in, like as Dominique mentioned at the start, the surreptitious recording. So I'm a fly on the wall. I'm not participating in the conversation and I'm recording. That's wrong. But we know a unionized workplace is a tripartite contract. So the union is effectively consenting. So I think if the union does it secretly, well, it's legal. And then, as Dominique and I mentioned, it's going to be, can they admit it into evidence and all of that. It's one of those things that you might want to have the discussion. I'm always of the view that, the union and the employer, I mean, you should have very strong positive labor relations. And it's one of those things that you might want to have the discussion and say, look, going forward, it's not going to be in our respective interests that we leave this thing open. Why don't we agree that when we have our step meetings or whatever we want to call them, we're going to allow all the note taking and we're going to allow union representation present, but there's not going to be recording. Because the employee's right to have a union rep present really covers off that right to recording. Your union rep is there to represent you, defend you, be a witness, take your notes. So what's the purpose of a recording? So back to what we said, if the union does it, it's legal. It may be admissible, but I think it's one of those things you want to get out in front of.
Mm-hmm. Here's something we haven't really discussed yet, a good question. If an employer discovers later that an employee has recorded a conversation, does the employer have a right to request a copy of the recording or of the transcript?
And do they mean that the person's still an employee or they're terminated?
I think we can probably address
Okay.
both. It's not
Yeah.
specific.
I mean, yes. I mean, you have a right to request. Like there was a previous question that said, "Do we have a right to request that it be taken down?" You have a right to request, and it's beyond just a request. You have a right to demand. The question is that employee going to comply? And if they're still an employee, and you're saying like because you've got confidential information, now we didn't consent to that. We want a copy, and if they won't, then you can discipline them because they're still your employee. If they're not your employee and they refuse, well, then you're going to have to get into legal action to try and recover that. And the reason why I say context is so important is, was that conversation, is it the HR person and the employee? And the HR person saying, well, I want a copy of that conversation. A court might say, well, you're the HR person, you deal with people every day, you have notes, you don't need it. But were there others present in that conversation? And there are other people's privacy, is that affected? Are we saying, as the employer, we know you took that recording and there are other employees that also didn't consent and they don't consent to have their likeness and their voice and their information out there in the public domain. So we want that back. So there might, and that might even make it more disciplinary if you're saying, and once again, I go back to the context. If we're a body that's covered by privacy legislation, you can say, we didn't, as an employer, we have a right where we have to get people's consent before we collect information and before we release information. You, without our consent, recorded your coworkers, and that's out there now, and we want that back. because we don't want to be in breach of privacy legislation. So there's different angles you can approach that depending on your context.
We also had a question, an interesting question that we haven't looked at that was pre-submitted, and it revolved around workplace investigations. Let me just find it here. Oh, so if an employee refuses to be recorded in a workplace investigation, how is one to proceed? And Brad and I kind of discussed that before the seminar. And Brad, maybe you want to share what you shared with me.
Yeah, I mean, I think that a workplace investigation, it's part of recording. Like, I don't think we should necessarily be totally fearful of recording. I do a lot of work with regulatory authorities where employees are interviewed by environmental officers, by health and safety officers. In the old days, you'd see that health and safety officer furiously scratching out notes, and then they'd give it to the person at the end and have them initial. And now it's just recorded, and I think it's better that it's just recorded, because if there's if the officer asked a bad question, or the officer was intimidating in the way they asked the question, that's all captured in the recording. So I don't think we should be fearful of recordings. And I think that as an investigator, or someone who acts as an investigator sometimes, like when you're investigating, you want to have that dialogue, and you want to be looking at the person in the eye and looking at their body language, and following up on the next question, and being writing notes can be very distracting. So I do think that recording investigations is a best practice, and it should happen. But if someone says, like, no, I'm fearful of being recorded, I don't want to be recorded, I think what you can say then is, okay, we're prepared to deviate, and we're prepared to do the interview. But just so you know, our notes, the notes of the investigator, will be what we'll be relying on, right? Because there'll be no recording. So meaning that the person can't then say, oh, they wrote it down wrong. Well, we gave you the option to have it recorded. So that's a strategy that I would use in that context.
Yeah, and I think that if you deviate, so the employees really doesn't want to be recorded, if you're doing the investigation alone, obviously then I think it would be a good idea to have someone else present to take notes that corroborates their own notes. And there's also the possibility in terms of deviation of having, the employee sign off on the evidence that was provided to the investigator after the meeting is done.
That's correct. Yep, that's good. A good idea.
There's a question here. If a family member, I'm sure it's in the healthcare center, that is not present, has hidden device in a patient's room, recording conversation between staff and patient, is that valid? I think that's a perfect example of something that would be deemed to be illegal under the criminal code, because it's that example where someone is not participating in a conversation who is recording, and the two participants are not consenting.
I agree.
Obviously, if the patient agrees or consents to be recorded, the fact that it's a family member that put the device in, like, that could be considered to be consent if the family member has consented. But I think this is an example where, oh, the criminal code could apply.
Yeah. I think you're right, Dominique, and I do. As I hear that example, I think of like residential care facilities, and I think when if the situation is there's a person's room, that person does not have capacity, which I think the question says, and there's a nurse and a personal care worker in there, and they're just talking, about the weather and about stuff, then that's illegal, right? Because those two people, the conversation is between the nurse and the personal care worker, and they're being recorded by the family member that's a third party. But if it's a situation where the personal care worker or the nurse comes in and they're doing a service or dealing directly with the incapacitated person, it could be a little different, right? Because the incapacitated person doesn't have capacity and is likely assigned their ability to consent to a substitute decision maker. And if that's the family who's doing the recording and they're interacting with the person, say, okay, move, I'm going to move you here. Okay, I'm going to put this. That could be a little different, right? So much of this is contextual, but I think just the blanket, the family putting the recording device in and catching all communications, I think that's not on. That's not single party consent.
All right, I think we can wrap that up. We have 38 seconds on our recording. So
Yeah, no,
I think we're
you
good
all
to close.
consented, by the way. We've got by joining. This is your consent.
Well, thank you so much, everyone, for participating. If you have some outstanding questions, you can reach out to either Brad and I, we're always available to help with anything that you need advice on.
Great. And thank you to everyone that helped pull this together. Thank you, Dominique.
Bye, everyone.
Thank you.